It's a pleasure being here today, and I thank you very much. Those people that know me know that they will not believe that I'm going to spend this whole time standing behind a podium talking without moving all over. I do want to let me qualify a couple things before we start. First of all, some of the things that I'm going to talk about, don't let them scare you if you're not doing them. The beauty with all of HR is until you get caught or sued, there's not a problem. Sorry. Today I want to, there I go. Yeah, good. Okay, that's a little better. Today I want to talk to you a little bit about the responsibilities that are in counties and municipal government as far as HR is concerned. And one of the things different, if you go talk to different HR people and you start asking them questions about things you have and need, make sure they understand government HR. I came from the other world. I was the head of HR for a grocery chain called Cub Foods. I was also head of recruiting and EEO for American Transair and head of another company called Herbalife. And let me assure you, when I switched over and came to this direction, I had to relearn a lot of what we're going to talk about today because you guys get to do it a lot easier and a lot different in government than we do in the private sector. And the other thing is I do know a little bit enough about your jobs to make me dangerous. For a while I was a Johnson County Commissioner, so I've unfortunately or fortunately, however you want to look at that, worked in county government also. So we're going to talk about what you should know about HR, some very important things right now with harassment and discrimination and the step-ups that have been taking place as to eradicating it. We're beginning to find out that a lot of issues have been caused because of these two very areas. So you're going to start seeing Uncle Sam, the big Uncle Sam, push a little harder. And they have now, after all these years, if you aren't aware, have turned all of this over to OSHA. So if OSHA didn't have enough to do, it's now been given oversight of some of the HR functions. We're going to talk about physical and verbal harassment also, which are completely different, but they are new and maybe not even in your employee manuals. How many of you right now, with show of hands, have an employee manual? Okay, keep your hands up. If your manual is older than 5 years old, keep your hand up. Oh, so most of you are pretty current then. That's excellent. We're going to look at some coming attractions of some future laws that we're still waiting. They were supposed to come out before January and they didn't, and now we're waiting to see if they're going to come out at all. And some of the new ones that were put into place, the federal military leave, there's a new Indiana military leave for spouses, if you're not aware of that. The wage and hour changes that we were told were going to happen, obviously we all know they've all been put on hold. But we just got some word out of Colorado where the case has been in court that it may be thrown out altogether, hopefully. And then we'll look at some OSHA increased penalties. If you're not aware, they have almost tripled some of their fines for just simple violations. And if you do and you do not in your county have some kind of safety committee, maybe one of the things you want to start putting together to look at, because they certainly will be They found out finally that they've left municipal government alone for all these years. But they found out that there's money to be had even in municipal government. So the OSHA has found its way into doing audits even within county government. Then we'll look at FMLA changes and some things that I want you to specifically know on FMLA. And then we'll look if you have any concerns at all. Who's responsible? How many of you in here as auditors are responsible for the HR? So the rest of you have an HR department? That's fantastic. As I go around the state to municipal government, the cities and towns, I know many of them still do not, and we're told that many of the counties didn't either, so we're trying to help out where we can. Ultimately, it is, and this is one of the things I want you guys to remember, ultimately the responsibility falls on your county commissioners. It shows up as one of their items that they are responsible for. You may get stuck with it in your county, but ultimately, if something happens, it is their responsibility. Why worry about it? Well, let me tell you a couple reasons. The lawsuits that are starting to happen in municipal government, not only cities and towns, but in several counties that I've been helping out, the numbers are getting astronomical. And we've also figured out that most government entities, i.e. a county or city or town, have these insurance policies that were created with about a $20,000 cushion. So I know that even a simple harassment or discrimination suit or some kind of violation, I know at a minimum I'm probably going to get $20,000 out of you because it's cheaper to pay off that insurance with the insurance of $20,000 than it is to take it to court. Unfortunately, it's been found out across the United States. And that's why, if you haven't seen any, we've seen an uptick in lawsuits in government entities in the last 5 years because of this extra money that's just, and I realize it's not extra money. I work for the city of Greenfield almost full time, and working there, I understand this is not free money. But let me assure you, the lawyers look at it as $20,000 free cushion money. So it behooves you to worry about it. It also, let's get simple. Most of what I do and most of what I work with is the way you should be treated and treating people anyways. It isn't because the law told you that you should respect the people you work with, that you should treat them with respect. Even in a termination, there's a way to terminate somebody and doing it with respect. So all these things, the more positive you can make anything, it lowers the potential liability of a lawsuit. Let me ask you. First one I've got up here is new hires in the county. Does your county follow the proper example in your employment, in your employee manual? If you do not, even if there is one little step that we skip. I get a call a couple weeks ago, and the department head said, "Hey, Mitch, I know I'm supposed to post it for 5 days and in the city building, and if it doesn't happen, because I already know who I want." You've never heard that, right? I already know who I want, so why do I have to follow through with the steps? And I said, what does your employee manual say? Well, it says I have to post for 5 days. But there is a little caveat that says the elected official, key elected official, has the right to go around that policy if he or she determines that we don't have any qualified candidates within House. And I said, so is it better to follow the policy and just walk through the 5 days, or to end up with a potential claim within your own government agency? Well, but I already know who I want. I said, let's put it this way. I've been doing recruiting all over the world. When I was head of for American TransAir, I literally flew all over the world hiring people. I said, I can hire somebody that I want as long as I go through the process. And yes, you may see it as a waste of time, but I'm going to tell you, the first time you don't follow every step in that manual becomes worthless. And if there are sections of your manual that, you know what, we haven't been doing it forever. I go into cities and towns and counties, and I'm starting to look at what's been written in your policy and procedure manuals. And I'll ask, because of having done this now for almost 40 years, do you guys really follow this process? No, Mitch, that's not what we've been doing. We do ABC instead of XYZ. The moment I hear that, that manual is a major liability to you. Because if there is any kind of lawsuit, any kind of problem, I'm going to use it against you. Well, how can you tell me you follow this manual if you don't even follow these simple steps? How many of you in your handbook have a little caveat that says, we're in an employment at will state? Anybody? Oh, the rest of you took it out? Cool. I'll bet you it's in there if you really look hard enough. We may be in employment at will state, but does anybody know where a lawsuit in employment law goes? It goes to a federal court. And the feds have already decided they don't believe in employment at will. So if you don't have a progressive disciplinary policy, you better get one quick. Yes, I can still terminate somebody in Indiana because I don't like you, because I don't like your hair. I don't like that you've got tattoos all over. But unfortunately, that doesn't stand up in federal court for a wrongful termination. Because the question's going to be asked by you, and I've stood in front of a couple federal judges that are in downtown Indianapolis. Mr. Ripley, did they follow their policy and procedure? Or no, let me rephrase it. Did you and your company follow that policy and procedure? Well, Your Honor, I have to be honest. We skipped a few steps. I'm not going to lie in front of a judge. I got enough problems. I don't need that too. But you need to make sure that if it's in that manual, you guys are doing it. If there's even a policy that's out of date, pleading ignorance is not an excuse. We'll talk a little bit about workers' comp and those silly first report of injuries. Is there anybody in here besides me who has gotten a few weeks after a person was injured, they come in and say, hey, I was injured a couple of weeks ago. I didn't fill out one of those forms, but I need to go to the hospital. Anybody in here? Let me tell you what happens. Why it is imperative that even for a simple scrape, a simple problem, that those individuals go and at least fill out the form. Even if you don't fill out the form, tell them, Just jot it down in a date and have it signed by a supervisor. That's legit enough. Had a situation in a major city in northern Indiana. I got a call from the mayor, and the mayor said, "Hey, Mitch, so-and-so scraped their knuckles on the back of a garbage truck." I said, "Well, that's cool. Sorry. I mean, I'm not sure what you want me to do about it." "Well, this was about a month ago. And if you were to look at his knuckles, his middle knuckle is double the size of a quarter." And I said, "And what did you tell him to do?" "Well, I told him to go to the hospital right away because it was workers' comp." So the employee went to the hospital. And as you know, when you go to a hospital or a doctor, what is the first question they ask you? Was this done at work? Or was this done out of work? It is a requirement they're required to ask. The moment he told them this happened at work, he walked down a road that he regretted. Yes, it did happen at work. The problem was he didn't turn in a form because it wasn't anything at the time he scraped his knuckles. But understand, when the hospital hears workers' comp, they begin a process that has been set for them by the federal government. And they understand that everything that happens with this is going to be covered through workers' comp. At the point in time that workers' comp, the liability company, finally got the first report of injury was 2 months later. And guess what they said? "We're going to deny this claim." Now, if you're not aware, the Indiana State Ombudsman for OSHA has sent a letter to all, well, let me rephrase that. If your liability company is in Indiana, they have all received a letter that said, "We expect you to start denying a workers' comp claim where a first report of injury wasn't turned in within that 72-hour reporting period." This is 2 months later. The liability company said, "We can't cover it. You didn't report it." So the individual went back to the hospital, and he told the hospital, "Well, I have to use my medical insurance to pay the bill because workers' comp denied it." And the hospital goes, "There's a problem. Under federal statute, they cannot switch boats and turn it under their medical. Sir, you're going to have to come up with $6,000 yourself." And that's when I got the phone call from the mayor. At this point, I'm not sure what she wants me to tell her other than, "Yep, that's exactly the way this law works." I keep telling people, just fill it out. Just fill something out and have it notarized or have it signed, admitted by a supervisor. You got yourself covered. What the mayor ended up doing in that, and I told her it was the wrong move, was she paid for the $6,000 out of the city budget. Let me assure you, that will come back to haunt you, as you all know, being auditors. But it's imperative that people begin to understand that they need to get these reports, the first reports, filled out, even if it's nothing. Yes, is it more legwork? Or if it's the auditor who's doing the OSHA 300 at the every year because you've got all these first reports, but they never went anywhere? You know what? I'd rather have a little more legwork on the front end than trying to tell an employee, "By the way, you didn't turn your first report into the county. It's going to be denied, and you're going to have to pay the bill yourself." Be knowledgeable about what's in your policy and procedure manual. Even if you have an HR department, I challenged the elected officials, and I told the county councils this a month ago. The same thing I'm telling you. Even if you have an HR department, you still should know what's in, as an elected official, you should know what's in that manual. I know you have a lot to do and so much more than you need, but you need to know what's in there. Because you need to make sure that you as an elected official aren't violating something that's in it. And let me assure you, it's very easy to violate something that's in that policy manual because we didn't know. Or it's been the way it's been in that policy written 20 years ago, and the system changed long since then, but it didn't make it back to the manual. Look at it. Make sure you know what's in there. Some of the things is, and this is more for you and to the council members, and I told the commissioners also this, that when your employees come into you as an elected official, we all want to be helpful. We want to be able to take care of their issues, and we want to give advice, and maybe we've experienced something that they're going through or some problem they're having. But how many in here besides me have a degree in counseling? Anybody? If you do not have a degree in counseling or a certified counselor, you will be sued. Simply counseling an employee without a degree or without a license, the same as practicing law without a license, is trouble. So is counseling your employees. And the kicker is, and I've seen it happen all over this state, well, Mitch, I told them, they asked me, what decision would I make? And I told them, well, this is what I did in this very situation. The moment they gave that piece of information, whether it's even simple as filling out the forms of a 457 plan, or what health insurance coverage do you think I ought to get? You don't answer those questions. You direct them to the experts in those areas, because the moment you give them an answer and something goes wrong, guess who's going to be sued? And you may have known this person forever, and that's what, Mitch, I knew him. I've known him for years and years. We grew up and went to high school together. If you give them information and it goes wrong. This is a true story. Individual gave counsel to an employee. You know, I had that same situation and I got a divorce. And I recommend, you shouldn't have to put up with that. You need to get a divorce also, because you shouldn't be there. It wasn't the employee who sued that elected official. It was the husband. So understand, I recommend to all department heads, don't play counselor. You can be sued and will be sued today for any advice you give, unless you have the credentials behind your name to give that advice. Where'd that go? So it wasn't me. Good. My employees would tell you I mess it up more times than that. Let me ask, has anybody ever in here given a piece of advice? Come on, we all have. We like to help people. And when we see an employee or somebody we work with hurting, we want to go to their aid. Is it working now? Okay, thank you. Be careful when you give your opinion. Not just the advice, but your opinion also. Because of your role, opinion can be viewed as fact. Well, Mary told me this, so it has to be the way it is. She knows what the law is. If you give your opinion, understand the employee will see it as fact. And ultimately, you could be accountable for that particular fact. One of the main areas, are you aware in your county that every municipal government in the state of Indiana and every other state in the United States is supposed to be providing your employees with sexual harassment and discrimination training every other year? How many of you ever done it? Okay, so we got a couple that have. Understand, your employees, this is such a high visible area with the federal government that they have put a mandate that nobody knows that we are to be training a sexual harassment, a discrimination, racial, every other year to all of our employees. March of this year, I'm sitting at a department head meeting in the city of Greenfield, and I said, when's the last time you guys had a training on sexual harassment? And everybody looked at me, well, never. The next department head meeting, I asked if I could come back, and we did one. At least get your department heads to begin to understand what's going on, because without that training, again, just because you didn't know is not an excuse. If your manual wasn't updated in the last 24 months, you probably do not have the new federal government, federal military leave. Now, understand, it's not much different than the old ones we had, but it is different from the pure fact that if you hear somebody ask, you see on the bottom bullet, it says USERRA, ERISA. If you hear somebody say something about, so are you following the ERISA guidelines for federal military leave? If you have no clue what that is, you're living with the old federal program, and there are some differences. And for the most part, the differences really go into that active duty and how much time you can give somebody to be off. Under the old program, I knew I had to give National Guard how many weeks a year? Anybody know? 2, absolutely. I knew I was going to give them 2 weeks a year to go train. That's now changed. It can 30 days at a minimum, and they now, unlike before, can apply for special training and special fun, as they call it, and that's now required under the ERISA. If they decide they want to apply for a particular program that the regular Army has going on, and it's going to be over a year, you have to grant it. If Uncle Sam gives them that little piece of paper. Before, the only reason we ever gave anybody time off if they were National Guard was the 2 weeks, and if they got called into active military service. Under the new law, or the changes that took place, there's a whole lot more there, and you do need to have somebody get real familiar with this, especially if you have anybody that is returning vet or is National Guard. because there are lots of opportunities for them to make additional money and receive additional training that we never had to worry about in the past. Questions on this at all? How many of you have the new one? Okay, a couple. That's good. This actually, I'm going to tell you the easy way to get this stuff. Google. If you go on your computer and just type in ERISA 2002, actually this has been in existence since 2002. Nobody's ever known it though. Just Google ERISA 2002 and it will bring up the entire new policy. It's that easy. Now, I will tell you that new policy is 20 pages long, but if you have some free time, I've taken and condensed down to a couple of paragraphs here, some very lengthy paragraphs, just to give you some highlights. How many of you are aware that there is a Indiana Family Leave Act, Military Family Leave Act? Okay, so we've got a couple here. Indiana passed a Family Leave Act that if my spouse were in the military, that an employee is eligible if he or she has been employed with the county for at least 12 months, has worked 1,500 hours during the 12-month period immediately preceding the day the leave begins, and is a spouse, parent, grandparent, or sibling of a military member. So this isn't just spouse. It is grandparents, it's a parent, and it's a sibling. If my sibling is in the military, I get access to this leave. Active duty is defined as full-time service. Active duty orders in the Armed Forces of the United States that exceeds 89 consecutive days. So if my brother was in the military and he had been on station somewhere, maybe in Iraq or maybe even Afghanistan for over 89 days, and I've worked 1,500 hours in 12 months for you, I am now eligible for this benefit. The Act provides for unpaid leave up to 10 work days per rolling calendar year during one or more of the following periods. What's key to you is in a calendar period, as long as it meets one of the requirements of who this person is, it was designed by our legislature to allow, if I know that John's coming home and I'm the spouse of John, it was created to allow me to take 10 days prior to them coming home, John coming home, so that I could get things in order. If there were bills or different coverages or different insurance or what have you that I needed to clear up, I now have 10 days. Doesn't have to be paid, but 10 days that you have to give me off to take care of what's necessary for John's return home. It really is not going to be that much of a burden for a spouse. Is personally, and I've talked to a couple of legislators that when they got into grandparent and sibling, I started to question, and their statement was to me, Mitch, what if that sibling is who they live with and who helps take care of their finances and everything while they're gone? Or what if it's their grandparents that serve that role? That's why they went as all-encompassing as they did. But you need to be aware that it exists. Yeah. I certainly, if I'm your HR person and you're going to take 10 days off, I would structure my policy to say that you are going to use your benefit time as part of that. But then I also believe you do FMLA the same way. Other questions on this? I put this in here. I know we all know what FMLA is. It's the Family Medical Leave Act that literally has been changed 15 times since it was originally enacted. Now when I write an FMLA policy, it's at least 3 pages long at a minimum because of all the additions that have been added into it. But I think it misses the point with our employees. And that's why I wanted to talk to you, because more and more I'm finding out, well, the employee didn't want to file. They've been on medical leave and took PTO time, but they didn't want to file for FMLA. And I ask, why? Well, they're just, they're afraid there's going to be a problem. I'm here to tell you, the only protection, I don't care how many PTO days they have, I don't care how many sick days they have or how many vacation days they have that they take off to cover that medical leave, their job is not protected. And I can terminate them legally while they're out on that leave. The only job protection that an employee has is through the 12 weeks of FMLA. Now, I always say you use your benefit time that they burn it up during the same time frame, because what happens in the communities where you aren't using it at the same time is I get my 12 weeks off for FMLA, but you know what? I also get 4 weeks of vacation a year. Plus maybe I get 20 PTO days. After those 12 weeks are up, employees love taking the 4 weeks vacation or taking the additional 10, 20 days of PTO. So your policy already doesn't talk about it. Utilize those benefit days that they have right along, but I challenge you to strongly recommend for their protection that they file for FMLA. I still don't understand the concerns about it, other than I think people are worried about being labeled by taking an FMLA. But I am telling you, for their benefit, it is the only job protection that they have while they're sick. Because even under a wrongful termination suit, if I can prove, let's be basic about it. If I don't need you for 12 weeks, why are you employed? Seriously. If I don't need you to do your job for 12 weeks, why do I have you? Unfortunately, or fortunately, depending on how you want to read this, businesses figured this out a long time ago. Government we haven't figured it out in our world yet. But I'm telling you it's coming, because I've already started to see it from now just getting involved a little bit with counties. I'm starting to get these phone calls from counties going, hey, what about this? They're not and I do not have to keep you. Let me ask you another question. Speaking of keeping, an employee is on workers' comp. Can I ever terminate that person? How many in here say no? Okay, those that say yes, and the rest of you don't know. Actually, under federal statute, their job is only protected for 12 months. At the end of 12 months, I could technically let them go. Stop paying workers' comp. But back to FMLA. Convince your employees it behooves them to take it. Send them the paperwork day one. If you don't have an HR department, that means the FMLA paperwork is coming out of your office. If you aren't aware, The feds have made this very easy. There is a federal cover letter that you send out to the employee. There is a form that says, we think you may be eligible for FMLA. File. Form that's already set up, that all you do is plug your name and telephone numbers in, and they give that to their doctor. So you don't have to create any of this. The feds have provided it all for us. And afterwards, if you want access, I can tell you one-on-one how to get some of these forms, but it's really easy. How many of your employees actually use the FMLA? Okay, so this seems to be, what's different about this side of the room than this side? Again, continue to have your employees do it. The beauty is with FMLA, if it's me, if it's my spouse, if it's my children, and now under some of the new caveats, if it's one of my parents, and I'm the one responsible for taking care of them, they qualify for an FMLA leave. The beauty with that is once they've been approved, I have 12 months to use that 12 weeks, which means, as I have in one community that I got a call from this week, she has 36 days left. She takes them intermittently. And she has 36 days for the rest of this 12-month cycle, which actually doesn't end until next July, to use those 36 days, and then she's done. And unfortunately, I've seen the evil part of this, so I have employees that play the game and use them as they can and then push the envelope. I will tell you personally, this is an area, tread lightly if you're going to push back. Because there's some new things. Everybody's heard of American Disabilities Act, right? Well, under the new, as of December of 2016, the new American Disabilities Act allows for even more playing with this FMLA. That's why you want them to use it, you want them to go through it if they're eligible. But they've also added a caveat. How many of you in here allow light duty? I know a couple do because I've received phone calls from your counties. And one in particular, that's policy in their manual even says when they're done with FMLA, they can come back on light duty, and we're going to work with their doctor, and we're going to work all we can to get them on board. One particular community just called last week and said, well, but the doctor said she can come back to light duty, but part of her job is to drive, part of her job is to interact with people, and the other part is lifting. The doctor said she can't drive, she can't interact with people, and she can't lift anything. And they, Mitch, can we keep her on FMLA? She has 36 more days, can we keep her? I said, if her doctor is releasing her from light duty because of that one policy you have in your manual, you better find something for that lady to do and bring her back to work. So make sure when you're looking at your policies that they match up with the things you really want to do. Because let me ask you, what do you do with a nurse who can't interact with people, cannot drive to see them, and can't lift up anything? Well, those of us that have devious minds, I can create a job that you don't want to do. And that's what I told him. I said, find all the job duties in the county that don't deal with people. She's not going to do any lifting, and she doesn't have to drive to do it. And give her all the jobs that nobody wants to do, and that's her job. And then I got a call back, said, well, she says that she gets to choose what she wants to do. No, she doesn't. That's what you need to understand. FMLA was written to help protect them, but we still get to drive the boat. And I get to dictate what they're going to do when they come back. Especially if you have a light duty policy. And as I go around the state to communities, I'm telling them day one, if I'm writing their policy and procedure manual, get rid of light duty. Because now, back to the ADA. Because of this policy that this particular county has, and we bring her back to this job, under 12 of 16 under ADA, that now becomes her permanent job. If you have light duty, under the way ADA changed in December of last year, when they come back from a medical leave or something and they need light duty for a while, and that's what your policy says, if they figure it out, they can now do that light duty job the rest of their work for your county. And it's totally legit. And we already received one lawsuit. But it's what the feds did, Washington did as they were going out of office in December, was to change this ADA just enough that makes, if you have light duty jobs and I'm in it, and I keep going back to my doctor saying, I can't do it, I can't do it, I can't do it, it becomes a permanent job. Now, it's why when you look at all these policies, you need to be looking at them or having your HR people look at them, the connectivity from one to the other. Because Washington has figured out how to connect the dots to make it tough for us. I'm still trying to figure out, and the last one is more for me. I'm still trying to figure out why employees are so afraid of FMLA. It is their job protection. Most of you are probably aware we have a lactation policy now. And if it's not in your manual, it needs to be in your manual. Well, there were some changes, again, towards the end of last year to this lactation policy. Before, I had to provide you unpaid time to go to a private room that was not a restroom, that I had to provide you with a refrigeration source, that I had to provide you with a room that can be locked from the inside and people can't see in or out. That people from the outside can't see in. That's what the law used to read. It still reads you can't use a restroom. You have to find a private room for them to use. But now it allows them to do it on paid time. So whatever it was before or whatever they were doing prior, and you were clocking them out while they went to lactate, now you have to make sure you pay them during that time frame. Minor change. Most of you probably were doing it already. They were doing it on a break time. So you're not going to notice a difference, but it just means now, and this is why it came into being. 2 break periods a day for some is not enough. And so the Fed said, okay, most people get a 15-minute break in the morning and an 8-hour day and a 15-minute break in the afternoon. And that's what they were doing as unpaid time. And if you had any more other than that, it was unpaid. And the Fed said, nope, all time is unpaid, and specifically, you cannot force them to take their break period when the rest of the employees take their break period to go lactate. It's not fair. To some extent, I understand and agree with that. But there is changes to it if you're not enforcing it. If you don't know where a female employee would go, what room, you better find one. If you do not know what refrigerator, what refrigeration device that a county employee would go to and put it in there, and it cannot be a refrigerator in the break room. It cannot be put in a refrigerator where people are taking their lunches and their drinks and stuff in and out of all day long. It has to be a special private. But I did get OSHA to agree to one thing, because I had this debate with them, because I have some small communities that literally are so small they can't afford refrigerators. And OSHA agreed that if your department doesn't have the money to allocate to buy a refrigerator, big, small, or whatever, that a cooler with ice is a refrigerating device. So that's how simple it can be, but understand you have to have something, because one of the things that OSHA, and this is another one of the areas that OSHA's been put in charge of. OSHA is going to come in, and the 3 questions they're going to ask you is, where is the room? Can I go there freely? Can it be locked? So it's 4 questions. And where's the refrigeration device for that breast milk? And they are asking those questions because most people have ignored this statute since it came into being. OSHA does have some other new directions. We're about done. They've been given access to the physical and the verbal harassment. And they are coming up with some workplace programs to deal with employee verbal harassment and physical harassment of employees. And they will be the arm and the hammer to come down on those 2 areas. They've also been given control over looking to see where you stand with LBGT. Regardless of what the state does or doesn't do, we still are somewhat governed by the federal government. And this group now falls, if you're not aware, it now falls as part of the EEO and discrimination up until, this was true up until 2 weeks ago, that as of December of last year, that fell into all the discrimination. The Second Circuit just put a stop on this particular issue as whether it does have protection under the Sexual Harassment and Discrimination Code. So we will know more here probably before the end of the year, unless it then goes to the Supreme Court. But understand that it is coming, depending on what this court decides. That you do need to make sure that you aren't discriminating against a gay or a lesbian individual. And spells it, and is it, I've gone ahead for the last few years, I've gone ahead and spelled it out in employee manuals that we don't discriminate against anybody. I don't care whether black, white, purple, green, male, female, in between, or whatever. We don't discriminate. And that's the way you should be looking at it, so that it is not an issue whatsoever in any kind of court in the land. hopefully we're going to get new information on both of those real soon as to what's going to finally happen. We're also, if you're not aware, and I've been doing HR too long now, we have come full circle. Back in 1980, when I started in HR, there were many of your insurance and many of your manuals that had pregnancy leave policies. And then we got the idea that they all became part of medical. We have now come full circle, and you need to be thinking about in your policy manuals, do you have a Pregnant Workers Fairness Act policy that basically states the same thing that your other medical policy does, that you're going to give them the time off, you're going to, if there's benefit time available, if they qualify, this would qualify under the FMLA. Basically, doing what you're doing, just stating it, that we're back to making sure that we're going to cover pregnant women. And I thought this was done until my youngest daughter was 33, was working for a company and got major harassed and discriminated against. And she was one of their executives because she was pregnant. She just called Dad. The ultimate goal is to ensure employees are no longer put in a position where they have to choose between a pregnancy and a job. And that, in my opinion, is a good decision. Nobody should have to choose a job, having a baby over the job. I should be able to do both. Any questions or concerns you guys have? I know that Stephanie said before at the beginning that you guys had questions that they received. Anything we can answer? Yeah. Yeah. You're right.
Any recommendations on how we acquire that info?
Yes. Because unfortunately, in the private sector, we've been dealing with this forever. But actually, the feds helped me when I was at ATA figure out how to take care of this. The easiest thing to do is on your applications is to have a tear-off form that actually asks all these questions. Some communities actually do it on a 3x5 card, and when they hand out the application, they have them fill out that 3x5 card. Doesn't have their name, nothing, just the job title they're applying for. And my bid is wait till they're employed and then give it to them with no names or nothing, so it's anonymous. And it's real easy at that point in time to collect all those cards. And the systems, and I don't know what systems you guys use, but I know the systems that the cities and towns use are capable of logging all that information. Yeah. Absolutely. You don't pull it out. That's why if you're doing it for a year, because the feds have been sent, I saw that report 2 weeks ago in the city of Greenfield. And they said, what is this? And I go, oh, I was dealing with this back in 1982. It's every year. When they start doing it right, you are going to get that form every year. So, and it's based upon, yeah, you have to use as much as, I mean, you know who the cards came from. You know where if you're like some of the county, Johnson County, where I'm from when I was county commissioner, I knew who the African Americans were. I knew if we had any Hispanics and if they left. So you will have to keep some track of it, but you can't legally match it up to a name. Other questions? Yeah. And I know we're over, I apologize.
Hi, I just wanted your contact information in case we have any questions.
My contact information? It's Mitch Ripley, MITCHRIPLEY, at HR Unlimited Resources. And it's the easiest way is to send me an email, and that's mripley, so MRIPLEY, and the number 2 at AOL.com. I don't always answer my phone, but I do go through all my emails and get to them, so it's the easiest way to get in touch with us.
Okay, thank you.
Okay, thank you. Any other questions? Okay, thank you.
Okay,